Dear students, you are welcome to Delhi Metropolitan Education. I am happy that now you have come in the ninth semester, and the topic of the day for you is drafting of pleadings and conveyance deeds. What is drafting? Drafting is nothing but making something. You see, when you ask an architect to prepare a map for your house or college or your mall or any other establishment, the job of architect is to draft the roadmap and blueprint for your building. Likewise, in law also, we are drafting pleadings. Pleadings here means a plaint or a written statement. Whenever a client comes to you as an advocate, he places few facts before you and asks you to present his case in court of law. So you have to draft an application on behalf of your client, or you are supposed to draft a plaint to be presented in the court, or if your client is opposite party, then you are supposed to draft a written statement on behalf of your client also. This is in short known as drafting of pleadings, that is drafting of plaint and drafting of answers or written statements. Then dear students, you would be drafting certain deeds also, and these deeds are conveyance deeds. Conveyance here means to convey. Suppose you want to transfer your property to someone, you want to gift your property to someone, or you want to mortgage your property. So whenever a person conveys his rights from one place to another, from one person to another, it is known as conveyance deed. So you would be drafting conveyance deeds in this ninth semester also. Now, see, this background shows you that this potter is making pot out of clay. What he is doing? He is making pot out of clay. So whenever raw facts are given to you by any client, your job is the job of legal potter. You will mold those facts according to legal framework. That is an art of drafting. Like this poor fellow is a potter making pots out of clay. You will also prepare plaint, written statements, or sale deed, gift deed, or any other deed required by your client out of raw facts given to you by the client. So, this is how the process of drafting starts. You start thinking over the facts given to you by your client, and you start drafting in your brain. Then you put it on a paper or on the computer. So your job as a lawyer is that of a legal potter. So all the facts given to you by your client, all those facts are in the process of your mind, your thinking, and you are molding those facts through your process of thinking. So this is, you see, the diagram shows that rough draft is ready. You have heard the client, you have noted down the facts, you have prepared a rough brief also. So this is how you see a rough pot is ready out of clay, and rough draft is ready out of the facts given to you by your client. Now this gradually you will see, as the time passes, your lawyer ponders over the matter, thinks over the matter, applies various principles of law in his mind, and then these raw facts or clay gets converted into a pot. Or in other words, I can say that raw facts given to you by your client gets converted either into a plaint or an application or a written statement or deed to convey the rights. And finally, when the lawyer is ready with your plaint, lawyer is ready with your written statement, or lawyer has prepared your agreement, lawyer has prepared your sale deed, so drafting process is over. Whenever a printout is taken from the computer, that means the final printout is before you. Like this picture, the pot is finished and ready. So your deed is also ready. Your plaint as required by you is also ready. Your written statement is also ready. So dear students, here are few books you can adopt, any one of them, for understanding the drafting, pleading and conveyancing. Now we start with plaint structure. What is a plaint? You see, plaint is a document in which the person filing a case in the court mentions all the facts which are necessary for the court to decide the case. So here we start with question number 1 or lecture number 1, that is draft a plaint in a case of specific performance of the contract. Your facts of this case may be imaginary or they may be real one. Suppose X agreed to sell his flat number 906 Designers Park, Sector 62, Noida, Gautam Buddha Nagar, with A for a sum of rupees 1 crore on 1st January 2017. Additional facts given by your client to you are that he received a sum of rupees 10 lakh as advance money, and this agreement was duly registered in the office of Sub-Registrar Noida, and the final sale deed was to be executed within 6 months from the date of agreement. Then your client says that A requested X so many times to execute the sale deed in his favor orally on mobile, and also sent him 3 emails also, but he kept on giving false promises. Thereafter, A served a notice dated 5th June 2017 to X by registered AD post for execution of sale deed on 20th June 2017. But X did not turn up for execution of the sale deed in the office of Sub-Registrar Noida on the given date, that is 20th June 2017. Now a further notice was given by A to X on 21st June 2017 by registered post for execution of the sale deed on 30th June. But still he did not turn up for the execution of the sale deed. Now A wants to file a suit for specific performance of the contract under specific relief act. As a lawyer, please advise. Now you are the lawyer, because now you are in the 9th semester. You are 90% lawyer now. You are to advise your client as to how to file this suit, how to draft this claim on behalf of your client. Your client has requested you to file a suit in a court of law for specific performance of the contract. Now coming back to the word pleadings, you will see that the pleadings are governed by Order 6 of CPC. All of you have read CPC. Pleadings here means plaint and written statement. You have read Order 6, Rule 1 of CPC, which says pleadings shall mean plaint and written statement. So what are pleadings, dear students? Pleadings are statement of facts in writing, drawn up and filed in a court by each party to a case, stating therein what his contention shall be at the trial, and giving all such details as his opponent will need to know in order to prepare his case in answer. So first party as well as second party, both will give their statement of facts in writing. The statement of facts in writing given by the first party who is going to file a suit is known as plaint, and statement of facts in reply to that plaint are known as written statements, or commonly known as WS. So you see, the writing of plaint as well as the written statement are based upon provisions of Code of Civil Procedure. Now you may ask, what is the definition of a plaint? CPC has not defined what is a plaint, but you must have read the book of Mr. P.C. Moga on law of pleadings in India. Mr. Monga has defined the plaint like this, that a plaint is a legal document of plaintiff containing a statement of claims and setting his cause of action with necessary particulars. And this document is sent to other party known as defendant to confirm or to rebut the action to be taken against him and to submit his version in the form of written statement. So in the plaint, you are supposed to write down everything which you expect that your opposite party should reply. So this is how plaint has been defined by Mr. P.C. Monga, and he has also defined written statement also. This written statement is a version of other party, and this written statement is a statement of defenses. It is known as WS in common parlance. That means a written statement in which defendant deals with every material fact alleged by the plaintiff in the plaint and also states any new facts which fall in his favor. And then after filing a plaint by the plaintiff in the court, the defendant has filed his reply in the court in the shape of WS, and then both the parties have a right to file replication also. Replication, as the name suggests, is the repetition of what has already been said or any ground of defense which has arisen after the institution of suit or after the presentation of the written statement. That may be raised by the plaintiff or by the defendant by way of subsequent pleadings known as replication. And replica of the plaintiff is also known as additional WS of the defendant when defendant says something in addition to his WS as replication. So pleadings, generally you have seen that how the case starts in a court of law. Every suit has to be instituted in a court of law by presentation of a plaint in duplicate. And this presentation has to be done before the proper court of the lowest grade competent to try the case in accordance with law. This is the mandate of section 15 CPC, that you will file your case in the court of lowest grade competent to try it. And every plaint should comply with the rules contained in Order 6 and Order 7 of CPC. Likewise, a written statement should comply with the rules contained in Order 8 of CPC. Now, dear students, whenever you start drafting, it may be drafting of a plaint, it may be drafting of an application, it may be drafting of written statement, or it may be drafting of any other document which you are going to file in the court. There are certain fundamental principles which you must keep in mind. The first and foremost principle of pleading is that your plaint, your WS, or your pleadings should contain facts and not the law. You are supposed to write down the facts only in your plaint and WS. You are not supposed to write down the law in your pleadings. Law is to be argued before the court later on. But as you know, you have read in CPC that foreign laws are treated as facts in our country. So if you are pleading some foreign law, then you will have to plead it as a fact also. And at the same time, mixed question of law and facts should be pleaded. Like you say that the plaint of the plaintiff is barred by limitation. Defendant takes this plea in his WS. So you will have to write down as to how this suit is barred by limitation. What was the limitation? Say, for example, limitation for filing the suit was 3 years, and now 4 years have already passed. Hence, the defendant is taking this objection that suit of plaintiff is barred by limitation. Next rule, dear students, is that pleadings has to state material facts and material facts only. Material facts here means the important facts, the important points of the case, maybe from the side of plaintiff or maybe from the side of defendant. And the next rule is state the facts in the pleadings and not the evidence. because evidence has to be produced in the court later on. Initially, plaintiff as well as defendant, first party as well as second party, they are to write down their facts in the shape of plaint or WS. And plaint and WS, as you know, put together are known as pleadings. And this is what we are doing today in the first lecture, how to draft the pleadings. So while drafting pleadings, the rule is that you will state the facts in the plaint and in the WS, but not the evidence. And at the same time, the next rule is that those facts should be stated very concisely, with precision and certainty. And all these facts are to be divided into paragraphs, and all those paragraphs must be numbered consecutively. Dates, sums, and numbers shall be expressed in figures as well as in words. Suppose you are writing that your agreement was for sum of rupees 1 crore. So you will write down this 1 crore in numbers as well as in the words also in the bracket, that a sum of rupees 1 crore. Outside the bracket it will be written in numbers, and within the bracket this amount shall be written in words. Dear students, you will see that form of pleadings, what are the various forms of pleadings, they are given at the end of CPC. There is an appendix attached to CPC, and that appendix A gives you various forms of pleadings. If you want to see any form of pleading, you can just consult appendix A appended at the end of the CPC, and you will find various forms of various plaints, various written statements, various forms of applications, how to draft it. You will get an idea. There is a format given in the appendix attached to CPC, which gives you forms of pleadings. Then what is next important for writing plaint and WS? If you want to plead misrepresentation, fraud, or breach of trust, or undue influence, then you must plead it in your plaint or WS. Suppose you want to say that consent to sale of property was not free. Your consent was taken under undue influence, or your consent was taken by the builder by way of fraud. So you must plead those facts which constitute misrepresentation, fraud, or undue influence. Then another important point here is that if legally there is some condition precedent before filing of the suit, so that condition precedent should be pleaded. Like, for example, you want to file a suit against central government or state government. Then you are supposed to give Section 80 CPC notice to the government before filing a suit. 2 months notice has to be given. So you must plead this factum in your plaint that a notice under Section 80 CPC has been served upon the state government or central government. Take another example. If you want to file a suit for rent and ejectment of the tenant, then the compulsory requirement of Section 107 TP Act, as you know, is that the tenancy of the tenant has to be terminated before filing a suit for rent and ejectment. So you will have to plead in your plaint that a notice under Section 107 TP Act has been served upon the defendant and his tenancy has been duly terminated. Dear students, drafting is an important point from your client's success point of view. Once you have drafted the plaint, no departure from original pleading is allowed. You cannot depart from your pleading. You cannot change your pleadings except by way of amendment, which is allowed in accordance with Order 6, Rule 17 CPC. So Order 6, Rule 17 may permit you the amendment of your pleadings. Then, while drafting your plaint or written statement, effect of the document has to be pleaded. Like you have entered into an agreement to sell or agreement to purchase a flat for a sum of rupees 1 crore. So briefly, you will write down what is the effect of that document. This is also requirement of Order 6, Rule 9, CPC. And as I have told you earlier, that if you want to plead malice, knowledge, fraudulent intention on the part of other party, then Order 6, Rule 10 requires that you must plead these facts as facts in your plaint. And you have seen that the notices which are to be given to the defendant should also be pleaded in the plaint. Like I told you, Section 80 CPC notice or 107 Transfer of Property Act notice, that notice has to be pleaded in the plaint, and this notice has to be written in the prior notice which is given to the defendant. In that notice also, it should be mentioned that the relevant notice under Section 80 or 107 TP Act has been given to the other party, that is state government or central government. Then, dear students, there are few implied contracts, implied conditions. So those implied conditions should also be treated in accordance with Order 6, Rule 12. Like you have seen in so many markets, that you go to the market, in the wholesale market, you purchase the grains from market at a certain price. You may pay the price later on, and if the price is not paid in 15 days, so there is implied contract that you will pay 2% rate of interest on also on the outstanding amount. Although it was not express term of the contract, it was an implied term of the contract that if the balance money is not paid within 15 days, then purchaser has to pay 2% interest also. So this implied condition, implied terms of the contract are to be pleaded in the plaint and WS respectively. Now, initially we have seen that in pleadings only facts are to be pleaded, not the law. Likewise, presumption of law in favor of party need not be pleaded. For example, whenever a check is issued, it is always issued for consideration. So, consideration of a check where plaintiff sues only on the bill and not for the consideration as a substantive ground of claim, in such cases, the presumption of law in favor of party that checks are always issued for a consideration need not be pleaded, because that is a presumption in favor of one set of the parties. Then lastly, when you have prepared your pleadings, they are to be signed by respective parties and their pleaders. And if party is not available, even power of attorney holder may sign the plaint or written statement on behalf of the party. And if the plaintiff or defendant is a minor, then guardian has to sign the pleadings on behalf of minors. Likewise, in case of lunatics also, the guardian of the lunatic has to sign the pleadings in accordance with Order 6, Rule 14, CPC. And lastly, when you have prepared your plaint or your WS, then it needs verification also. Every plaint, every WS has to be verified at the foot of the plaint or at the foot of the WS by the plaintiff or defendant or by one of the parties to the pleading. Suppose there are 4 plaintiffs in a case. So out of 4, only one plaintiff can verify the facts written in the plaint. And sometimes some other person is authorized to sign the plaint, one who is acquainted with the facts and circumstances of the case. Like you see, few business class people, they keep one of their clerk to maintain the accounts, and that clerk or munshiji, he knows the facts of the case more than the owner of the building. Suppose the munshiji is collecting rent from various tenants which are kept by the landlord. So, and the landlord is not in a position to go to each and every tenant and collect the rent. So he has authorized his munshiji or the clerk to collect the rent. So that munshi, now that clerk is also authorized to verify the contents of the plaint because he knows the facts. He knows the facts on behalf of his landlord or his master. He is the servant and he can sign on behalf of his master. He is authorized to verify the pleadings also. And while verifying the pleading, the person who is verifying the pleading, he shall specify by reference to be numbered paragraphs of the pleadings which he verifies of his own knowledge, and separately those paragraphs which he verifies upon the information received from his advocate or other sources. So separate paragraphs are to be verified. Suppose Munshiji knows the what was the amount of rent due from a particular tenant, so he can verify this fact from out of his own knowledge. But what is the cause of action in the suit? What is the valuation of the suit? Whether the suit is time barred or not, whether the court has jurisdiction to try the suit or not. These paragraphs are written by the advocate of the client. And these paragraphs that Munshiji or plaintiff is verifying on the basis of information received from his advocate. So that he can do. So this is a preliminary picture before you as to how to draft a plaint. What should be the essential ingredients of a plaint? What are the rules for framing a good plaint? Now moving on, we have to draft a model plaint, and for that we will take up a model plaint structure before you, and we will begin with one example of filing of a suit or filing of a plaint in a case of specific performance of a contract. Like we have seen the facts that A has agreed with B to purchase a flat in Noida for a sum of rupees 1 crore, and he has given 10 lakh rupees as an advance money also, and remaining 90 lakhs will be paid at the time of registration of the sale deed. These are the terms of conditions. So on the basis of these brief facts, you are supposed to now draft a plaint for filing a suit of specific performance of the contract. See, you can presume your own facts also, unless in the examination the facts are given in the question paper itself. If no facts are given, you are at liberty to presume your own facts and write down the plaint. But before you start writing plaint, you must be aware as to where the plaint is to be filed. There are so many codes. You will see that section 15, 16, 17, 18, 19 and 20. That is 15 to 20 of CPC. They are dealing with the provisions where to file the plaint. You have drafted a plaint, but you are not aware where to file it. If you go to the court compound, there are say more than 12 courts where you will file it. So for that, dear students, you will have to understand the hierarchy of courts in India. What is the hierarchy of courts in India? Where you will file your case. So this is a short summary before you, that on the topmost, that is the apex court we have, that is Supreme Court of India. And Supreme Court of India has original, appellate as well as writ jurisdiction, and specially petition jurisdiction is also there. Then you know we have high courts in each state. High courts also have appellate, revisional and writ jurisdiction. Then coming down, the Court of District Judge and additional district judges, they too have unlimited civil jurisdiction. They have appellate jurisdiction. they do have revisional jurisdiction also. Then coming down again, the civil judge senior division court also has unlimited jurisdiction above rupees 25,000 in UP. I'm talking of UP. This limit of jurisdiction may be different in different states. Then at the bottom of the hierarchy comes civil judge junior division. He has original jurisdiction of trying suits up to rupees 25,000. Suppose you have drafted the plaint for specific performance of the contract and the valuation of the flat is 1 crore. So proper court for filing a suit for specific performance of contract will be civil judge senior division, not civil judge junior division, because the jurisdiction of civil judge junior division is limited up to suits having valuation of 25,000 only. May I tell you, dear students, that these hierarchy of courts you have seen, I'm coming back to it, that if suppose civil judge junior division or senior division has decided a case in its original jurisdiction, its first appeal goes to the court of district judge, second appeal goes to the high court, and lastly apex court is there. So in this hierarchy we see there are 4 sets of courts. But all these civil courts, my dear students, are actually one if appeal goes up to the Supreme Court. And I may tell you that judge of the appellate court steps into the shoes of the trial judge. Or in other words, the powers of appellate judge and powers of trial judge are equivalent when appellate court is hearing an appeal. And at the same time, the judge of appellate court cannot exercise more powers than that of a trial judge while sitting as appellate judge. So the equation is that power of appellate court are equivalent to powers of a trial judge. And this is the mandate of section 107 clause 2 CPC. If we are talking about the civil cases, and if we talk about the criminal cases also, the principle is same, that the appellate judge always steps into the shoes of the trial judge, and this is the mandate of section 386 of CRPC if we start talking about hierarchy of criminal courts in India. So let's have a quick look at the hierarchy of criminal courts in India. The topmost court, as you know, is Supreme Court of India, and they are authorized to pass any sentence given by law. Then comes High Court in each state. Again, they are authorized to pass any sentence authorized by law. Then comes District and Sessions Judge, which includes additional district and session judges. They are also authorized to pass any sentence which is authorized by law. But the only restriction on their powers is that death penalty given by a district and sessions judge or additional district and session judge is subject to confirmation by the High Court. This is the mandate of section 366 of CRPC. Then comes next in hierarchy, lower side, is assistant session judge. Their powers are up to 10 years or fine or both. Then comes chief judicial magistrate and chief metropolitan magistrate in metropolitan areas like Delhi, Bombay. Their powers are up to 7 years of imprisonment or fine or both they can avoid. Then comes lastly judicial magistrate class 1 or metropolitan magistrate. They have powers to pass punishment up to 3 years or fine up to 10,000 rupees or both. And lastly, at the bottom of the hierarchy comes judicial magistrate class 2, and he has power of punishment up to 1 year or fine up to 5,000 rupees. So this is hierarchy of criminal courts. Why this is important before you? Because when you want to file, suppose you want to file bail application. Your family member has been arrested and you are supposed to file your bail application. Where you will file? Unless you know the law and unless you know the hierarchy of criminal courts. So drafting is one part, and filing it in appropriate court is another part. And initially, when you start writing your plaint or your complaint on criminal side, the topmost line of the drafting is in the court of so and so. In which court you will file your civil case, in which court you will file your criminal case, in which court you will go for anticipatory bail, in which court you will go for regular bail, unless you know the hierarchy of courts and their powers. Hence, these two charts, one hierarchy of civil courts and one hierarchy of criminal courts, is before you for understanding how to draft plaint and where to file it. So if I may talk about civil courts or criminal courts, the theory is same, that power of appellate courts are equivalent to power of a trial judge while hearing an appeal. If appeal is going from bottom court to Supreme Court, the powers of all the judges at all the four stages are same. The even Supreme Court judge cannot pass more sentence what could have been awarded by the judicial magistrate class 1, but the condition is that Supreme Court must be hearing appeal from the same order. And then one thing is more important, I will tell you at this juncture, that suppose you have contested your case up to Supreme Court, you have 4 judgments in hand, one from the Court of Civil Judge Junior Division, then judgment of District Judge, then judgment of High Court, then in appeal judgment of Supreme Court. You have 4 judgments in hand. But these 4 judgments are not to be counted as 4, because doctrine of merger says, this is a common law doctrine, this doctrine says that all the 4 judgments, maybe on civil side, maybe on the criminal side, if the appeal has gone up to Supreme Court, all the 4 judgments will merge into one. Only the final judgment of the Supreme Court will be implemented, not all the 4 judgments. And dear students, what merges with each other is only the operative part of the judgment. It is not the entire judgment which merges into each other. It is the operative portion of the judgment. Final result of the judgment, it gets merged, and whatever is said by the highest court is now applicable. So in other words, if I may conclude this discussion, then appeal is nothing but continuation of the trial. Appeal is nothing but continuation of the suit on civil side and continuation of appeal on the criminal side. Continuation of the trial on criminal side. So if suppose the trial court has awarded 1 year punishment to someone, district judge has dismissed his appeal, he confirmed 1 year imprisonment, then the accused person went to the High Court. High Court also dismissed his appeal and sentence of 1 year was confirmed. Then that fellow went to the Supreme Court. Supreme Court also unluckily dismissed his appeal and upheld the sentence of 1 year granted by the judicial magistrate class 1. So we have 4 judgments in hand. 4 times 1 year penalty was confirmed. So what do you think, that the accused will get 4 years punishment, because 4 times it has been upheld that 1 year imprisonment is to be given for the offense which he has committed? No, my dear students, all these 4 judgments will merge into one, and accused has to undergo only 1 year imprisonment and not 4 years. So in nutshell, I can say that decree of appellate court always supersedes the decree of the lower court, because doctrine of merger says merger in law means absorption of a thing of lesser importance by a greater importance, whereby the lesser ceases to exist but the greater is not increased. Merger, what is merger, dear students? This merger is defined as absorption of a thing of a lesser importance by a greater one, whereby the lesser ceases to exist but the greater is not increased. the judgment of the lower court gets merged into the judgment of the higher court. But the judgment of higher court does not get increased. Although the decree of the lower court loses its identity and individuality in the presence of decree of a superior court. Or take another example, suppose you have filed a case of specific performance of the contract of purchasing a flat from builder in 1 crore rupees, and you have won your case from the Court of Civil Justice Senior Division. Then builder filed an appeal in the Court of District Judge. The appeal was dismissed. Builder went to the High Court. Appeal was dismissed. Builder went to the Supreme Court. Again, the appeal was dismissed. Now I, as a plaintiff, have 4 judgments in my favor. So can I get 4 sale deeds executed in my name on the basis of these 4 judgments? No, dear students, all these 4 judgments are not 4, they are 1, because appeal is nothing but the continuation of the suit. And only the decree of the highest court, that is the Supreme Court, will be executed. As you have read in the CPC, the decree follows every judgment. When the case was decided by Civil Justice Senior Division, the decree was prepared. When the appeal was decided by the district judge, the decree was prepared. When the matter was heard by the High Court and decided by the High Court, again a decree was prepared. And finally, when the Supreme Court decided the case, again a decree was prepared. So I, as a plaintiff, now have 4 judgments and 4 decrees in my favor. But I cannot have 4 sale deeds in my favor of 4 flats. I'll get the execution of only 1 decree, that is the highest decree prepared by the Supreme Court. So to recapitulate and summarize what we have studied today while writing a plaint in accordance with the order 7 of CPC, essentials of a plaint are before you at a glance. That you start writing a plaint. So first of all, the first line which you will write, the first line which you will type on your laptop or computer is the name of the court where you are going to file your plaint. And this name of the court will be decided according to the hierarchy of courts and their jurisdiction. So hence the first line, the very first line of the drafting of a plaint or a WS is the name of the court where you will file your suit. Then next line comes, number 2 is suit number. You will leave this place blank as suit number dash dash of 2020, because the suit number will be awarded by the computer of the court or by the clerk concerned of the court. Then, dear students, you will write down the name and description of the plaintiff. Complete name, parentage, age, residence address of the plaintiff has to be given in the plaint. If there are more than one plaintiff, then the name and description of all the plaintiffs is to be given in the plaint itself. Then comes 4th point, that is versus, against whom you are going to file a plaint or a case. After versus, you will write down the name and description of the opposite party, that is defendant. And if there are more than one defendant, then of course you will have to mention the name and description of all the defendants in your plaint. Then comes the body of the plaint. What are the facts? What was the agreement between the parties? What was the flat number to be sold? How much amount was fixed? How much amount was paid in advance? How much remains in balance? In how many days the sale deed was to be executed? All these facts will constitute the main body of the plaint, where you will write down the facts and material facts only, and not the law. as I have seen and we have told you earlier also. Then in the plaint, you will write down the cause of action. What are the bundle of facts due to which you came to the court? What is the cause of action? Cause of action is that the builder is not executing sale deed in my favor. I am ready to pay balance money, but he is not ready to sell it to me because the rates of flat have gone up and he wants to sell it to somebody else and not to me. This is my cause of action. This has to be written in the plaint. Then next comes valuation. How much is the valuation of the suit? The valuation of the suit in this case, in this illustration, is 1 crore rupees because the total cost of the flat agreed between the parties is 1 crore. Then you will write down the limitation, whether your suit is filed within limitation or not. Generally, the limitation is decided by Indian Limitation Act. So you will have to write down in the plaint that your suit is well within limitation. Then you will mention the jurisdiction of the court also, that this honorable court has jurisdiction to decide this case. And jurisdiction has three portions, three aspects of jurisdiction. That the court has territorial jurisdiction. Suppose the flat was situated in sector 62 Noida. So territorial jurisdiction goes with the Noida court. You cannot file this suit of specific performance in New Delhi because the property was situated in Noida. Likewise, pecuniary jurisdiction also. Pecuniary means with reference to its valuation. How much is the valuation of the suit in terms of money? That is 1 crore. So a suit of 1 crore will be filed in the Court of Civil Justice Senior Division because the jurisdiction of Civil Judge Junior Division is already limited up to 25,000 rupees. In UP, it is different in different states. Then subject matter wise also, whether the court has jurisdiction or not. So away from body of the plaint, these four words are important: CVLJ. Please remember these words: CVLJ. C stands for cause of action, V stands for valuation, L for limitation, and J for jurisdiction of the court, which you must write down in your plaint. Then lastly comes the relief clause. What kind of relief you are going to claim from the court? What you want from the court? You want that I am ready to pay the balance money and the sale deed should be executed in my favor. Then signature is also part of the plaint. Plaintiff will sign the plaint. He will mention the place and date where this plaint was signed. And lastly comes the verification of the plaint, and after verification, this plaint has to be signed by the plaintiff as well as his advocate also. So dear students, this is all about for today's lecture. Next lecture we will be taking the essentials of plaint in an improved version, and you are requested to read order 6, 7 and 8 of CPC. Next time when you will come to the class, please come prepared with order 6, 7 and 8 of CPC. So thank you very much for the day.